those of you who say hamjakutana na sister kotini, in case we meet, don't think I'm there to pray. Don't think I'm there to pray. Yes, because the main challenge I find every time I log into the court system and I appear, there's a time I was representing one of the sisters, and the magistrate asked me, "Are you sister so and so?" I said, "No, she's my client." "So what is your name?" I repeated again, "Sister Immaculate." The magistrate looked at me and asked me, "Are you sure you are an advocate?" "Yes." "May I have your practicing certificate number?" I just started laughing, then I gave her. And she was like, "Sister, why are you laughing?" I said, "Because every time I log into the court system, the first thing the judicial officers are always asking for is my practicing certificate." She told me, "It's because we are not used to seeing nuns practicing, that's why." So don't confuse, when we meet in court, it's business. It's law as it is.
When you are doing a Christian marriage, make sure that the minister who is administering in the Catholic Church will got the sacrament, but who is the administering the exchange of vows is actually registered and authorized by law to do so. Don't come and look for Sister Ima. You say, "Hey, Ima, she is very conversant with that law." So she is the person we want to officiate our wedding. My friend, we are not licensed to perform weddings. A prenuptial agreement states that all that I own, and you stipulate, Runda Elan this, Brado K what, will not form part of the matrimonial property. So that the moment you say, "Yes, I do," and you start to kuza sukuma nyanya, ukimbizana na files, now that's when you start building your wealth, and that is what will form part of the matrimonial property. But what parties had before should not form part of the matrimonial property unless they have one agreed. You know, can marry me and I tell you I used to have a shamba in Kitengela, it can be part of the matrimonial property. Or the other thing which people do, I have a piece of land in Karen, I acquired it before we got married, but was not in a position to develop it. Now that you've come on board, and we combine effort to develop that piece of land. In case now we decide to divorce, that piece of land, even if it was mine, but you've come in and contributed, you are supposed to get a share. What happens to property acquired before marriage? Do you have a share even if you don't have financial contribution? Contribution does not necessarily mean it must be financial. And those who have married rich women here, na kuachaka kwa nyumba, ukingangana kukimbizana na mfanyikazi wa kuku waekee kuku chakula na ng'ombe zikajue dara. Then you take this milk to the dairy. Then anakuambia kimenda studio area kuna kabiashara nilisikia tunaweza anza get materials. Men, do not be fooled. Come up with a diary. Come up with a diary, right? On the 31st May 2025, Ima went to give a seminar to ACK men at Jericho. And he left me at home. Nikaambiwa niende chakula ya ng'ombe industrial area, niende kuku sijui dhika nifanye. Diarize all this so that when you start divorcing and you are in court and you want to work a share, you will be in a position to tell the court, "Here is my diary." Same to women. Dialize it and everything which you are told to do, and you know, here you are not using what? Cash. Because when you are using cash, it's easy to prove. You just go to the bank and you get your bank statement. But here you want to convince him, you went to get chicken's feed from Vika. How will you prove that? Dialize. Ayano babysitting mtoto leo nikimbie sijui sema wapi. Dialize. So in the case of JOO versus NBO, it's a 2024 case. The Court of Appeal stated that a spouse can still be entitled to a share of matrimonial property even if they have not made any financial. Exactly. However, the burden of proof lies with the spouse claiming a share to demonstrate their contribution, which can be monetary or. Now, if you don't diarize how we
Employment Act stipulates that the normal working hours per week, it should be 45. This means you can work from Monday to Friday, 8 to 5 p.m. Then on Saturday from 8 to lunchtime. However, a person who works at night should not work for more than 60 hours. So if you work in an organization where you are told to report to work Monday to Friday, and on Saturday and Sunday you are left free, thank God, it's a favor. However, your employer is only entitled to give you 1 off day per week, and it doesn't matter whether it's a Sunday, a Saturday, a Wednesday, a Friday, so long as it is 1 day per week. What are unfair grounds of termination? One of them is pregnancy. You'll find there are some organizations where even ladies, it becomes difficult for us to get employed, especially when you are young, because employers fear, I will employ Immaculate today, and after 3 months, she wants to go for maternity leave. Yes, so pregnancy, you should not be discriminated because you are pregnant. However, if you allege that your employer is discriminating you because you are pregnant, the burden of proving that discrimination lies with you. Then we have leave days. You are not supposed to be fired, or they are not supposed to terminate your services because you've requested you'd want to go for your annual leave. It's your right. You can also not, they can also not terminate your services because you've joined a union. Article 41 of the Constitution of Kenya 2010 provides that everybody in the country, they have a right of joining a union. That's why even employers themselves, they have a Federation of Kenyan employees. It's their union. So if you join a union, you can't be asked to leave because you've joined the union. Then we have participating in lawful strike. You can't also be terminated because you have participated in strike. But kindly note and listen very well, I've said lawful strike, not just any strike. What are the advantages of making a will? A will helps to avoid squabbles between dependents over the estate of the deceased. It also allows the testator to decide with a sober mind who shall inherit from his estate. And that's why we always advise people that when you are making a will, make sure you are in a sober state of mind. A will also enables the testator to benefit other people. And on this, I'm going to elaborate. When I say other people, what exactly do I mean? If an individual dies without leaving a will, there is the risk of not benefiting those individuals who are not directly related to him. That is the family members. If they were supporting somebody who is not a family member and they die without a will, then he will not be in a position to benefit from his estate. Also, a will helps the testator maintain control over his property after his demise. And it also entitles the testator to appoint a personal representative of his own choice to administer his estate. I want us to take note that in Kenya, there is no property in a dead body. This was stated in the case of Pauline Ndete Kinyota Maingi versus Rael Kinyota Maingi. What does this statement mean? I want to elaborate further that in case somebody has written in their will they want to be cremated and the testator decides to bury them, even if you go to court after the burial has occurred, 90% chances are that case you are going to lose. And that's why in this case
that I've told you, the court ruled that there is no property in a dead body. So if the testator decides to bury you according to your wishes, well and good. As a parent, when you are distributing your property, you should make sure that even girls have been considered in the will. Otherwise, they can move to court and contest that will. So the way you will give portions to your sons to inherit, it should be applicable also to the girls. Now we go to the types of will. I had earlier mentioned that there are two types of wills in Kenya. We have an oral will, which is provided for under Section 9 of the Succession Act, and there are some requirements. And one of the requirements is that an oral will should be made in presence of 2 or more competent witnesses. I know you might ask yourself, sister, what is a competent witness? A competent witness in this scenario is somebody above the age of majority, that is 18 years and above. He should also be of sound mind. However, when the will is made, the law provides that the testator or the person who made the will is supposed to die within 3 months. So when the person does not die within 3 months, this will lapses or it becomes ineffective. And I know you'll ask me, why does it become ineffective? When this rule was put across, the legislatures recognized that after 3 months, the possibility of the witnesses forgetting what the testator said is very high. And that's why this requirement was put into place. I want us to look at polygamists, where we have a polygamist who has sons and daughters. This is provided for under Section 40 of the Succession Act. And also in the case of Kanyi versus Mabioria, the court held that under the Kikuyu custom, if a man with 2 or more wives died without making a will, his land is shared equally among the houses. So each wife and her children, they are known as units. So the houses never die when there are heirs to these houses. And it is irrelevant whether the wives are alive or not. We have a medical attention. Section 34 of the Employment Act provides that the employer should make sure the employee have sufficient and proper medicine during illness, and if possible, medical attendance during serious illnesses. This one, most of the time, it applies in these factories where injuries can happen at any time. However, when an employee also gets injured at a place of work, they have the mandate of informing their employer that they are unwell. Also, when they get sick, even if it's not in a place of work, they have the mandate of informing that their employer that they are sick. They just don't assume that he will not. We go to sexual harassment. The law provides that where an employer has 20 employees and above, they are supposed to have a sexual harassment policy. This is provided for under Section 6 of the Employment Act. And under that sexual harassment policy, it should define what sexual harassment is. It should stipulate the procedure that an employee should follow when they have been subjected to sexual harassment in launching the complaint and pursuing any remedy. There are various types of employment in Kenya, and I was saying it's important before you sign any contract, you get to know the type of employment in which you are getting yourself in. So I'll start with the casual employment. Section 2 of the Employment Act states that a casual employee is a person whose term is paid at the end of each day and whose terms of engagement are not more than 24 hours. This is very common with us in Kenya, especially those people who practice farming, where you get somebody, they work for you for 1 day, you pay them, and that contract is terminated. Then we have the fixed term contract. A fixed term contract, this has specified period of employment or defined as, which define the work and task. They may be terminated on account of misconduct or end of the period, or by notice, or by other lawful reason. Then we have a probation contract. A probation contract goes for a period of 6 months, and it can be renewed for a further 6 months, because the Employment Act section 42 provides that a probation period can go for a term of 1 year. However, where a party wants to terminate a probation contract, either the employer or the employee, they are supposed to give a notice of 7 days, or they pay 7 days in lieu of notice. Then we have oral or verbal contracts. These are contract of employment or service where the terms are not reduced into writing. In Kenya, it is most commonly with the house girls. Many of us have house help at home, and when we employ them, we don't give them a written contract. However, it is paramount to note that the burden of proving or disapproving an alleged term of employment falls on the employer. That is provided for under Section 10, subsection 7 of the Employment Act. However, Section 9 of the Employment Act stipulates that an employment contract which runs for 3 months and above should be reduced into writing. Section 30 of the Employment Act provides for sick leave. Every employee is entitled to sick leave so long as they have worked for 2 months and a half, 2 months and above. The first 7 days, they are supposed to be given sick leave with full pay. The second 7 days with half pay. The third 7 days, they are not supposed to be paid. If this persists, then they are supposed to furnish their employer with a medical certificate, and the employer is at a discretion of either dismissing them under medical grounds. However, this may vary depending with the institution. Some institutions don't go with 7 days, but instead for them they give 1 month, 1 month, 1 month, then they can terminate. So also if there is a human resource policy and procedure manual which stipulates otherwise, it is still okay. We have a maternity leave. Section 29 of the Employment Act provides that a female employee is entitled to maternity leave for a period of 3 months. However, they should give a written notice to their employer of at least 7 days, stating that indeed they are pregnant and they are expecting a baby, so that they can be released to go for maternity leave. It is some of the employees at times tend to assume that when the employer sees they have their tummy has swollen up, they will assume that they are pregnant. Kindly note that you have the duty of furnishing your employer with a certificate or with a medical report or a certificate showing that you are expectant, because nowadays even cancer and tumors are there. So don't expect that she will automatically, or he will automatically assume it's pregnancy. We have maternity leave. Section 29, clause 8 of the Employment Act stipulates that a male employee is entitled to 2 weeks paternity leave. There is always a question which people ask, where somebody has the official wife and the mpango wa kandos, are they also entitled to paternity leave?
So how do you go about it? But it is paramount that when you have been employed somewhere, many organizations will always ask you about your marital status. So if you've not stated whether you are a polygamist and you've stated one wife, and a slave queen is expecting there, don't expect to get another paternity leave. A disciplinary process is a formal process that is involved to address issues of misconduct by the employees at workplace. The case of Kenya Revenue Authorities versus Mengina Salim Murjin and Postal Corporation of Kenya versus Andrew Keitanui has set a high standards for the conduct of disciplinary hearings in Kenya. It is paramount to note that every time when you are doing a disciplinary process, the employer should be guided by Section 41 of the Employment Act and the principles of natural justice. That means that the disciplinary process should be transparent, should be fair, should be respectful, and impartial. The process of disciplinary begins with the issuance of the show cause letter to the employee. This show cause letter is served to the employee, and the allegations which have been leveled against him should be captured in this letter, and if there is any evidence also which the employer has, needs to be captured in this letter. So the letter should be clear and concise on when the employee is supposed to respond to the allegation and what action should be taken if the employee fails to respond to the show cause letter. It is important also to note that an employee should be given ample time to respond to the show cause letter. In organizations where there is human resource policy and procedure manual, then the provisions of the policy should be adhered to strictly. Where we don't have the policy, we should be guided by the Fair Administrative Actions Act and also Section 41 of the Employment Act. After the show cause letter has been issued to an employee and they have responded, if the employer is satisfied by the response of the employee, then the case can stop at this moment. However, if the employer is not satisfied, he is supposed to proceed with the disciplinary process. And this process, the second thing we should follow is the issuance of a notification letter. Kindly note that the notification letter should specify the date, the time, and the venue for the hearing. It should clearly outline the reasons for inviting the employee to the hearing, and the letter should also inform the employee of their right to be accompanied by a witness of their choice. And the witness can be a fellow employee or a representative of the union. That is, if the employee is under any union. Why do we allow them to be accompanied by somebody else? This provision ensures that the employee has support during the hearing, and it bolsters the fairness of the process. Financial technology is the use of technology and innovation to improve, automate, or create financial services and products. Fintech or financial technology combines a number of things. We have banking, we have payment, we have investing, lending, insurance, with technology such as software, apps, blockchain, and data analytics to make financial processes faster, more accessible, and more efficient. I want us to look at the key examples of financial technology in Kenya. We have mobile banking and payment, where we have apps like M-Pesa and PayPal. We have digital lending platform, those of us who acquire loan via online. We have cryptocurrency and blockchain, e.g. the Bitcoin. We have the InsurTech. This is a driven insurance solution. We also have a robo-advisor or an automated investment management. For one to open a fintech company, what are some of the requirements which you need to have? One, you need to have a clear business plan. You also need to have a minimum paid up capital share of 5 million Kenya shillings and above. You need to have a university degree or a formal education in the relevant fields. You also need to have at least 8% of your total risk-weighted asset. You also need to have 5 years of experience in finance or in technology, and you need to maintain 20% of all your liability in liquid assets. You also need to have in place a strong risk management system. You need a secure IT infrastructure. You also need to have a clean record, criminal record and credit records. You also need to adhere to the customer protection measures in case of any harm.